Good afternoon, everyone. My name is Alan Stone. I'm a partner at Milbank LLP in New York and a 1987 graduate of the law school. And to my right is Katherine Maddox, who's the head of the clinical programs here at Tulane Law School. And to her right is Clarence Roby Jr. I'd say the one and only Clarence Roby, but he's not the one and only. There's another one in the room. Today, we, I think, are here really to shine a light on, primarily to shine a light on the amazing work that Katherine and her colleagues are doing in the clinics here at Tulane Law School. I've had the pleasure of hearing a lot about it as a member of the Dean's Advisory Board, and I thought it would be really important for the general Tulane community to understand and recognize the great work that's being done here. Clarence and I are here really just to hold forth extemporaneously on our own experiences in contributing to the social justice cause, and hopefully to inspire others. I think one of the messages that we want to impart today is that all of us as lawyers can have a role in this, and there's, you can help in big and small ways, and it doesn't take that much time or even that much money to really further the cause. So if nothing else, we want to make hopefully inspire people to do their part and to figure out ways that they can contribute as well. I'm going to turn it over to Katherine, who will tell you about the clinics and some of the great work that's being done, and then Clarence and I will chime in with some of our own experiences. Katherine.
Thank you, Alan. Thank you all for being here. It's very exciting. When Alan asked me, can you all hear me? When Alan asked me to come speak about the clinics, I first of all was very honored to do that and very excited to share, because I'm very proud of the work that my colleagues and our students get to do. And I know as alumni, maybe many of you might have been in clinics. I know that some of you were. And I really think it's just such an amazing opportunity to have students not only learn the skills involved about being a lawyer, but also develop the passion and realize that they, as individuals, can actually make a difference. They can make a difference in someone's life, but they can also make a difference in the community in which we live and move that arc of justice that we all think about closer and closer towards a just and fair community. And so one of the things I was just telling Clarence and Alan before we started was that this also gave me the opportunity to sit down with my colleagues and really ask them to tell me about what's been going on in their clinics, because although all we work in close contact with each other and shared spaces, we don't always hear all the details of their cases. And after I got a chance to hear some of those details, I was quite frankly even more proud of my colleagues. So I'm going to go through and talk about each of the clinics and some of the highlight cases that they've been handling recently and share that with you. So I'm going to start, and I am a visual learner. I always tell my students this. I'm a visual learner. I like pictures. So that's what I have for you all, is some pictures. So to start, we're going to start with the Civil Rights and Federal Practice Clinic, which of course handles all variety of civil rights types of cases, from fair housing cases to police brutality cases to employment law discrimination cases. And recently, some of the highlights, the picture on the left is a case, obviously it's a housing case in which a local property management company had refused to rent to a family, saying that because they had two children, a 7-year-old and a 5-year-old, that were not of the same gender, they could not rent to them. And the property manager told them that that was against Louisiana law, which of course is not true. And so that this family could not rent a house in their price point in a neighborhood for their child to go to school. And so the clinic, on behalf of this client and the family, filed suit and were able to win that suit and win a settlement. And also, of course, stop this. They were working with the Fair Housing and were able to send in some ringers, I think. I don't think they call them ringers. I think they have a different name for them. But apparently found that this was, in fact, a practice of this property management company, that they were telling folks that they couldn't rent to people with children of different genders, that they had to have separate bedrooms. So that was a very exciting victory. And you see in the picture, a very happy client who is just receiving a settlement check. She came to the school to pick that up from the students. And of course, Professor Blacksher, who's the director of the clinic, is in the picture with her, sort of having that moment after quite a lengthy litigation of that success. Another fair housing case that the Civil Rights Clinic dealt with also recently is from an uptown landlord who very specifically was quite rather publicly said he was renting to young skinny white girls. And he was harassing them, including grabbing them on their body parts. With at least one young woman at a lease signing, he would walk into their apartment unannounced when they were showering. So the clinic brought lawsuit against that as a housing discrimination case as well. And that case settled. The landlord was prohibited from entering the units and was also prohibited from directly contacting the tenants. He violated the settlement agreement, and the court had to make clear that he would be held in contempt of court if he were to continue to do so. So those are sort of the two of the big housing successes, fair housing successes that the clinic has had recently. In addition, they've been handling a number of police brutality cases. The one that's pictured there from the Fifth Circuit is a case that involved the Shreveport sheriff, in which the client was beaten by 4 Shreveport police officers while handcuffed on the ground after having been pulled over with a broken taillight. The lower court held that the officers were not protected by qualified immunity. However, the Fifth Circuit reversed. And this is a photograph of the team outside the Fifth Circuit after oral argument. The clinic did seek cert with the US Supreme Court, and the Cato Institute filed an amicus brief in support of the clinic's position. The Supreme Court denied cert, unfortunately, but Justice Sotomayor did write and observe that the Fifth Circuit's opinion was highly questionable. So although that wasn't a victory, we can't win them all, but what we can do is keep fighting. And the clinic is also fighting in another case, another brutality case that the clinic has, which is they filed suit in Jefferson Parish against the Jefferson Parish School Board and the Jefferson Parish Sheriff's Department for an incident that involved a 10-year-old disabled Black child in school, where the child was in the principal's office and had a temper tantrum. They called the police. The 911 dispatcher advised the officers that this student was on medications. But nonetheless, when the police officers arrived, they tried to put handcuffs on this child. This is a 10-year-old child. They tried to put handcuffs on the child. The child resisted. So they threw him to the floor and put a chokehold on him. They held him for 4 hours without allowing him to speak to his parents and interrogating him. So that suit is actually in progress now. So in addition to sort of these housing discrimination and police brutality cases, the clinic also, the Civil Rights and Federal Practice Clinic also handles quite a number of EEOC cases as well. These cases, of course, the larger federal cases take a lot of discovery and depositions and a lot of work to get through. So they're very time-consuming cases. Now we're going to move to the Criminal Justice Clinic, which is the clinic over which I'm the director. So I will try not to spend too much time here. But One of the things I actually wanted to share first that I don't have a picture of is sort of hot off the presses. I was actually telling the dean and Clarence and Alan this just a moment ago. I learned this morning that one of our clinic clients, the governor, just signed a clemency petition yesterday. And so this is for a woman who has served 30 years of a life without parole sentence. She is 68 years old now, and her sentence, her life without parole sentence is commuted to 99 years with immediate parole eligibility, which means that the students who are working on the case, we will now be preparing for her parole hearing, and we'll go before the parole board, and hopefully we will succeed and she will be released again after serving a 30-year sentence. So, but another sort of positive note too that I wanted to share is the exoneration of Mr. Quanteo Reeder. Mr. Reeder was a client of ours since 2009, and Mr. Reeder, who you can see is pictured there with myself, my colleague, Professor Sheila Myers, and the two of the many students who worked on his case. And on his case, we represented him on state post-conviction, in which we discovered that the state had failed. This was a homicide case, and Mr. Reeder was serving life without parole. And he, from a 1993 conviction, and he was convicted on the basis of the testimony of one eyewitness. And the state had failed to disclose to the defense counsel that the main eyewitness had a prior federal felony conviction for perjury. They had disclosed that the eyewitness had had a felony conviction for battery, but not for perjury. We learned about this perjury conviction, obviously many years after the conviction, and we came to represent Mr. Reeder and filed a state post-conviction. We argued it through the state court, and the state courts said, well, yes, it's true they failed to disclose this exculpatory evidence, but it was cumulative because the state had revealed that he'd had a battery conviction. And so just adding another felony conviction, even though it was for lying, would be just cumulative and wouldn't have had an impact. The state court denied the post-conviction, and we took it and filed a federal habeas petition in federal court, and it went up to the federal Fifth Circuit, where again the Fifth Circuit also denied our petition. We filed in the United States Supreme Court, and the United States Supreme Court ordered the state to respond. Typically in these habeas petitions, the state doesn't automatically respond. So being ordered by the US Supreme Court to respond to the habeas petition actually, to us, demonstrated that they had some interest in the issue. And it perhaps might have something to do with the long history of the suppression of exculpatory evidence out of Orleans Parish. With the order coming from the Supreme Court, the new district attorney's office went through its files and looked at the old district attorney's files and learned that there was other exculpatory evidence that hadn't been disclosed, including the fact that that same eyewitness had identified an alternate suspect in 2 prior different occasions. And additional evidence was also disclosed. And finally, the district attorney agreed that Mr. Reeder was in fact not the person who was responsible for this homicide, but it was in fact the alternate suspect. And so in a very moving courtroom event, the district attorney agreed that the conviction should be vacated. The judge vacated Mr. Reeder's conviction. The judge and the district attorney both apologized to the victim's family for the injustice and apologized to Mr. Reeder. And the victim's family and Mr. Reeder actually had a very tearful exchange where they declared their affection for one another and wished each other well. It was I have to say, it was really moving. The clerks afterwards say, we don't get to see many good things happen in this courtroom. So it was very nice to have that experience. So the other slides I have up here are to talk about some of the longer term projects that we've done in the criminal justice clinic, representing juvenile lifers. So in 2012, the US Supreme Court in a case called Miller said that it's unconstitutional to sentence juveniles to life without the possibility of parole. And of course, Louisiana had been doing that for quite some time. And we had over 300 people who had been sentenced to serve life without parole in Louisiana for offenses that occurred when they were children. So when that happened, when the US Supreme Court said that that's unconstitutional, the question then became, well, does that apply retroactively or is that only moving forward? And that was for sort of initially up to the states to make that decision. And the Louisiana Supreme Court appointed the clinic to represent a client in the test case on whether or not Miller was going to be applied retroactively. And so we were able to argue that in front of the Louisiana Supreme Court, that it was, our argument, of course, was that it was retroactive and should apply to all of the other folks who were incarcerated. The Louisiana Supreme Court, though, did not agree with us, and it took going up to the US Supreme Court in a subsequent case called Montgomery, in which the US Supreme Court said, yes, it is actually a rule that has to be applied retroactively. And so then the question became, how do we implement that rule? If the only sentence for a homicide in Louisiana is life without parole. And so there was no sentencing statute under which we could resentence all these juveniles. So the issue became, well, what sentence should they be getting? And that became an issue for the legislature. And the clinic worked very closely with the Louisiana Center for Children's Rights and the Public Defender's Office and the Innocence Project. And we worked collaboratively with students participating in strategic planning and thinking about how we could help to draft a law and advocate for a law that would provide parole eligibility for our clients, because we at this point are now representing a number of these people serving life without parole sentences. Excuse me. It took 2 years at the legislature before finally a statute was passed, but one was passed that provided parole eligibility after 25 years. And you see pictures here of two of our clinic clients who we represented, who were finally given parole eligibility, and then after parole hearings in which the students represented the clients, our clients were granted parole and were released. The woman up above, you can see that in the blue, that's our client, and next to her is her daughter. And you have to understand, the woman in blue was incarcerated when she was 16, and that was her daughter who had grown up her entire life without her mother. Matter of fact, the daughter had been born while the mother was incarcerated. The bottom picture is me getting one of those great hugs that you never forget. This was a client who had served 40 years from the time he was a 15-year-old kid. He was incarcerated in Angola State Penitentiary, and he went into Angola back when Angola was known as the bloodiest prison in America. And he was there for 40 years. This was his first time stepping across that boundary line. And now he was he was 55 years old, 56 years old. I will tell you, before he got released, he was a very quiet man. But before he got released, we were sitting waiting at the hearing, and I asked him what he wanted to do when he was released. And he said, "What I want more than anything is to eat my mom's sweet potato pie." And then he went into the most graphic description of his mom's sweet potato pie. You can tell he was obsessed with it for the last 40 years, talking about the bubbly butter on top. And this was a very, quiet, taciturn man. So it was clearly something he was looking forward to. Another area that the Criminal Justice Clinic has worked on and had a success that we're very proud of is we had a number of clients who were serving life without parole sentences, not for violent offenses, but for falling under Louisiana's habitual offender statute. It's like what often people refer to as the 3 strikes, you're out. And for a period from 1996 to 2001, Louisiana had an extremely draconian version of that sentencing, where a third or more offense regardless of what the underlying priors were, was a mandatory life without parole sentence. And so we had clients who were serving life without parole for nonviolent offenses. And we've tried to challenge those convictions and those sentences, and we fought all the way through state court, and we lost, and we lost, and we lost. We fought through federal court, and we lost, and we lost. I used to say we are the biggest losers. We keep losing and losing. And finally, we lost in every court. There was no other way to litigate. But after 7, 8 years of fighting on behalf of these clients, it was very hard to just leave them. And so we sat with the students and we asked, well, what can we do? And the answer that the students came up with was, well, okay, they have life sentences. What if we just changed and made it parole eligible? We technically aren't changing the sentence, we're just changing the eligibility for parole. So we worked on a draft of a piece of legislation. We got a sponsor, and the bill actually passed. The students were able, in the picture, you see the picture of the students there in the Louisiana legislature. That's after the bill had just passed. And both students, one was able to testify in the Senate subcommittee and one in the House committee about what the bill's impact would be and how it affected folks. And so ultimately this provided parole eligibility for approximately, we don't know exactly, but between 250 and 300 people who were serving life without parole sentences. So those are some of the big areas that the criminal clinic has done work in. And the one last thing I will mention, because it feeds into something else I'll talk about. The other project that we do is we work with students go into the prison to help present and train counsel substitutes. These are incarcerated people who are serving as jailhouse lawyers and who don't get much training in the prison system, and they are representing other incarcerated people who don't have lawyers on their state post convictions, their federal habeas, where you're not entitled to a lawyer. And so the students go in the spring and train counsel subs on one of 2 different legal topics. So now I want to talk about the domestic violence clinic, which represents survivors of intimate partner violence in civil court. They seek protective orders, divorces, and support litigation in child custody cases. And one of the unique things about the domestic violence clinic is they have this civil court aspect of what they do, but now, and I'll talk about it in a minute, they've joined with us in the criminal justice clinic, and we're working together on something called the Women's Prison Project, so that the students in the domestic violence clinic get to go and do both civil court cases, but also do some criminal work too, which is a nice mix and opportunity for those students. So currently in the domestic violence clinic, they are in the 8th day right now of a hearing on a contested protective order and child custody case in which the client reached out to the clinic after her abusive partner attacked her while she was pregnant. And one of the things we see is that this is actually a very common event, is that abuse will start when a woman becomes pregnant. That's sort of, in many times we've seen this as a sort of a catalyst for the beginning of abuse. Very recently, not very recently, the students currently are also preparing for delivering an argument before the 4th Circuit. In that case, they are challenging a trial court's practice of assessing victims with costs if they don't follow through on their application for protective orders. So in other words, women who are applying for protective orders, if they didn't follow through, the court was assessing them costs. And the problem, of course, is it's failure to recognize that often women will not follow through with protective orders if they feel doing so is actually putting them in greater jeopardy. And so that's the challenges that the students are getting prepared for right now to argue in the 4th Circuit. Some highlights from last year, students represented a former sex trafficking victim whose abusive partner threatened to turn her over to her former sex trafficker. And when she escaped to a different state, he followed her and took their child from her. The clinic then represented her in months of litigation and were finally able to get a court order reuniting the mother with the child and giving the mother a permanent protective order from the abusive father. When the father sought review by the Fourth Circuit, the students represented their client in the Fourth Circuit and prevailed, and the Fourth Circuit upheld the order protecting the child. On average, the domestic violence clinic provides advice, counsel, and representation to an average of 90 survivors every year. So as I mentioned, the Women's Prison Project is a collaboration between the Domestic Violence Clinic and the Criminal Justice Clinic. And we are, in that project, we are representing criminalized survivors of intimate partner violence. So the vast majority of our clients are women who have been convicted or are charged with a crime due to intimate partner violence. And most of them are charged when they've killed an abuser in self-defense. So since our launch a little over 2 years ago, we've secured the freedom, who are actually out now, of 7 women. The 8th will be out in 1 month. Of course, we are going to hopefully be adding to that very soon. And next week, in fact, we have a hearing in Baton Rouge, a post-conviction hearing in which students are arguing that the trial lawyer was ineffective for failing to introduce an expert in intimate partner violence at the trial in order to help the jury understand the dynamics of intimate partner violence. And that's one of the things that we see quite commonly is that the dynamics of intimate partner violence often, one of the questions that people are always asking is, well, why didn't she leave? And what we know is that leaving is the most dangerous thing in many instances that a woman can do in a violent situation, and that she's the best judge of when it would be safe to leave. And yet that kind of information isn't something that the public commonly understands. And so what we need to do is train the bar and to train our community, judges and juries, as well as lawyers, about the complicated dynamics of intimate partner violence and why it is that some of these cases, we can't just look at them at a snapshot in time. We have to look at the big picture. And that requires the lawyers to engage in broader advocacy and in making sure that the jury and the judge and the prosecutors understand the big picture of what's been going on. And so this is one of the other goals of the Women's Prison Project, is to make sure that we're educating our community, as well as obviously representing our individual clients. As you can see, some of our clients in the pictures above, most of these women, one of the interesting things I will say is, as you can see some of the pictures where I'm standing, now I'm quite tall, but these women were most of our clients are incredibly small women who are being attacked by a much larger person. And so they pick up a weapon, and with one stab wound to the shoulder, which is almost the most common injury, one stab wound, and they hit an artery, and the person who they will say they loved and cared about then dies. And now they are facing a homicide conviction. One of the women, as you can see, hugging with the flowers, in her case, the appellate court actually wrote, she was being attacked and raped, and wrote, well, she could have escaped through her bathroom window. Instead, she defended herself with a knife and protected herself. But it was literally wrote in the appellate opinion that, well, she could have escaped through the window. And I would just make the observation that I can't imagine a situation where a man in his own home, when someone is attacking him, would ever have been suggested that he should crawl out the window to not to have to defend himself. And so one of the things we see is this incredible disparate treatment between men and women in these situations of self-defense. And our self-defense laws are really primarily focused on a sort of male-on-male model of self-defense, the barroom fight, for instance, and do not reflect some of the nuances and issues that are very much a part of intimate partner violence. I love the picture, if you'll see, our one client who now proudly wears her Tulane Law School t-shirt with the names of her team. Her clinic student who worked on her case are on the back of that t-shirt. And I've seen her a number of times, and she's come to the school to talk to our students, and she always wears her t-shirt. So that's always a very exciting aspect. In addition to representing individual clients and teaching our community, we've been able to work on a task force. The legislature created this survivor-informed task force. I was the chair of that task force, and my colleagues, Professor Becky Konkar and Professor Stas Moroz, who are working in the Women's Prison Project, brought their expertise in the dynamics of domestic violence to the task force. And based on their testimony and work, the task force issued a written report that has been then presented to the legislature and is hopefully going to be the basis for some legislation that will help make our laws a little more reflective of the experience of trauma victims. We also have another fellow who, and this is sort of gets back to what I was talking about with the Criminal Justice Clinic, a fellow whose work is to work with the counsel substitutes in the women's prisons specifically to teach them about the unique dynamics of intimate partner violence and how those can be used to fight their clients' cases, and how to best and most effectively help those clients who are doing pro se representation. So that's been a very exciting expansion of our project there too. I'm sure I'm going way over time. I'm going way over time.
No, it's all right. Keep going.
See, I thought I wouldn't have enough to say. Yeah, that's never happened, right? So Environmental Law Clinic, they have been doing amazing things too that I was so excited to learn about. So I'm going to start talking faster, which is going to be terrible. But okay, but I just don't want to leave anyone out. So recently they won really a groundbreaking decision here in Louisiana, the first environmental justice court decision in Louisiana, in which the district court wrote a 34-page scathing report saying that the Louisiana Department of Environmental Quality has been improving permits without taking a look at about how those permits are affecting communities of color who live along what we call Cancer Alley, which is where all the petrochemical companies are building up. And they were going to be building a plastics factory. And so the clinic represented the communities there to talk about, you're doing this without taking a look at the impact that this will have on that communities. Another case very similar to that they've filed is with the EPA, the Equal Protection, I'm going to get this wrong. The filing with the EPA, a Title VI investigation. The Title VI investigation is a civil rights investigation in which their argument is that the Louisiana Department of Environmental Quality permitting process is itself discriminatory and discriminates against members of the communities of color that live in, again, on Cancer Alley. And that it's this systemic racism in the environmental decision-making in Louisiana. And the EPA did issue a powerful letter of concern, which has prompted the clinic to work with the court on creating a plan for the issues about the racial inequities to be part of future considerations. This work in discriminatory environmental practices a lot of it is based on some of the work that the clinic has done in issuing and doing research studies. They've done 2 peer-reviewed studies that were published and received national attention. The first was looking at data to determine that Louisiana parishes with higher levels of air pollution had higher rates of COVID mortality from COVID. And this report actually led to an invitation. The Environmental Law Clinic has working with it on their staff is Dr. Terrell, who is a PhD, and she is part of the Environmental Law Clinic, and she actually spoke to Congress on this issue of the connection between air pollution rates and COVID mortality. The other report that they did that also was a basis for the two lawsuits was that the air pollution significantly contributed to higher cancer rates in that group. I'm really over, aren't I? Okay, First Amendment. Tell me when you're going to get the big hook. I'm going to get the big hook. So the First Amendment clinic, again, I'm just going to, I hate to do anyone short shrift, but they've been doing wonderful work. This is a new clinic, 2 years in the making, and yet they've already been representing public school students sent home for wearing Black Lives Matter masks. They represented protesters arrested for protesting the death of George Floyd and protesting on abortion matters. They've been representing government employees disciplined for social media posts, law professor charged with contempt for releasing a video of police misconduct. They've represented high school students disciplined for online posting regarding Black History Month. A third grader who was made to recite the Pledge of Allegiance. New Orleans street performers cited for failure to have a license. Union organizers removed from public property. And one of the things they're focused is largely on press and First Amendment speech. And, you know, one of the things is that they've noticed is that there really are very few lawyers who specialize in that area here in Louisiana. So they're really very much filling a gap. On the Immigration Rights Clinic, again, a new clinic that we've had that's just been going for 2 years, again, doing some amazing work. They've had students representing Afghan evacuees who've come to the U.S. and have settled in the New Orleans area. The clinic students have filed applications for temporary immigration protection for them. Some of the students, they've been representing immigrant youth under the special immigrant juvenile statutes that allow juveniles who've been abandoned by or neglected by their parents. And in the time that the clinic has been running, they've represented 30 juveniles over the last 2 years to get them with this, to provide them with this unique juvenile status. And one of the other significant pieces of work that's had a national impact from the immigration clinic is their issuance of this report, No End in Sight. In that report, the clinic studied 499 habeas cases out of Louisiana, people who were challenging their unlawful detentions. And what they learned about was that these were people who's already had been determined that they should be returned to their home country, but they weren't being returned, they were just locked up. And in many cases, they couldn't be returned because the home country wasn't taking them. So they're just sitting in jail. And the average time that they were sitting in jail at this point was 1 year. And that it was disproportionately Black immigrants who are being detained in this way. And that this report has been cited by a number of circuit courts around the country to show the disparate impact of our detention policies. In our juvenile advocacy clinic, the primary goal that the juvenile advocacy clinic is focused on has to do with competency of juveniles to stand trial. And in the time since post-Katrina, we all know the impact that Katrina had on the mental health of our community. This is particularly true for juveniles. And so the Juvenile Advocacy Clinic has been regularly challenging the competency of juveniles who are facing the delinquency court. And in doing so, when there's been successful, they've made over 200 competency challenges, and the vast majority of them have been successful, which allows them to then go from delinquency to a child in need of care provisions. And so that has been very successful for those clients who then get care instead of simply being locked up. And the last but not least is our Legislative Administrative Advocacy Clinic, in which the students help draft statutes. And many of us turn to them for advice when we are working on legislative matters to help us in the drafting of statutes or evaluating statutes moving forward. And these students write statutes with the help of legislators, and they do a mock or a moot where they present them to the legislature. And some of those bills actually have been made into law. And so I'm going to now stop talking, even though I had to rush through the last. I apologize.
Katherine, thank you very much. That's just amazing, the work that the clinics are doing. I'm just going to talk a little bit about my own experience doing pro bono work. I have always been much more of a corporate lawyer and trial lawyer. I have about 40 trials under my belt, all of them civil. Most of them, fighting about money for rich people. And along the way, I started doing a fair amount of pro bono work at my current firm in New York, especially. And I started in areas that are, I think, ripe for lots of need, and that would include housing in New York City, where there are some horrible landlords and lots of difficult issues, and also representing immigrants who are being abused by their employer, and a number of other different types of cases. And about a little more than 5 years ago, Brian Stevenson from the Equal Justice Initiative came to the annual meeting of partners for my firm and gave a presentation. And after the presentation, the chairman of our firm said to him, we'd really like to form some kind of an alliance with you to help you out with pro bono cases. So they went down to Montgomery and met with Brian, and they said, how can we help? And he said, well, I need the most help in Louisiana. And my chairman said, I have a perfect guy for you. And so that's how I got involved, initially with criminal cases, something I'd never done in my career before. My worst class in law school, actually. It was eye-opening in so many ways. And in some sense, I've been kicking myself since then for not having gotten involved in it sooner, because the impact that you make doing this work is just incredible. So I have two cases that I'll talk about. One actually was here in Louisiana. It was my first case, and it was a juvenile lifer case that Katherine talked about. My client was convicted of second-degree murder at the age of 16 and thrown into Angola. When I got his case, the task was really to get him resentenced to life with parole. But as we started doing the investigation, the fact investigation and the mitigation investigation, we really became convinced that he was innocent. And it was really probably through a lot of luck that we ended up getting him released. The DA dropped all charges eventually. We were able to piece together a case that in fact he had been convicted by a non-unanimous jury. And it was during the period between Ramos and the Supreme Court, US Supreme Court, deciding that Ramos was not retroactive. And because we had presented a white paper to the DA really demonstrating innocence, it was, I think, an easy call for the DA to agree to drop the charges. The other case that I was involved in more recently, about 2 years ago, they were starting a new chapter of the Innocence Project in Delaware. And that's where I originally practiced law for about 19 years. And I was called by the person who was starting it and said, would you like to join our board? Which I did. And it was really their first case that they had was a fellow named Mark Purnell, who, again, a 16-year-old convicted of murder. he himself, remarkable, second grade education, got his GED while he was in college, or while he was in prison, and even started college classes. He wrote a pro se brief, 126 pages, that convinced the Delaware Supreme Court that he was entitled to a new trial. So that's where I came in. It was a pretty easy task, actually. As I said, I batted cleanup. But it was really a case where the resources of a big firm like mine was able to turn the tide, because we had 20 associates on this case, and we scoured the fact record. And then what we found out was there were no less than 6 disclosure violations, including a videotape of a witness saying, "Mark didn't do it. I know who did do it, and he told me he did it." And they never handed that over. And so he spent 16 years in prison for a crime that he didn't commit, and was exonerated about 3 months ago. So I mean, my message really is that even a corporate lawyer who knows nothing about criminal law can get involved in these things, and in big ways or small. There are lots of organizations like the Louisiana Center for Children's Rights, or even the clinics and others, I'm sure, in your state, that would love to have somebody just review a record, take a look at a trial record, see what you see if there are holes in it, or do part of a fact investigation, or do some legal research. There are just any number of ways that you can get involved, and it's the case all over this country in every state that the resources on the defendant's side of the V are very, very limited. And a lot of times, having somebody just take a day or two to pitch in can make a tremendous difference in a case. So, I just think people shouldn't shy away from doing this work, and it's probably the most fulfilling work that you'll ever do.
Good afternoon. I'm Clarence, Roby, and I had the pleasure and the benefit of being this guy's classmate. And I think Alan, in his own humble spirit, is really not taking credit for an accomplishment. And he and I've had this conversation, so he can be mad at me later. I don't want to embarrass him. I'm in private practice, and I don't do pro bono work if I can help it. But unfortunately, in my criminal practice, I've probably, contrary to what my wife would have me admit, I've done far too much pro bono work. And Alan and I have tried to come up with ways that we can highlight some of the accomplishments that Katherine has talked about regarding the clinical program that we're also proud of here at Tulane. But what I share with Alan is, in my practice, especially my criminal practice, I happen to be one of those crazy lawyers who think that I can wear both a civil and a criminal hat. And I wear the criminal hat primarily because I try to service folk who live in my community who look like me, who can't necessarily afford me. And when I can move resources in my firm to try to represent folk who look like me, I try to do so. But there are a lot of us in this room who are alumni, who come from big firms, who have the means and the resources, who have those firms like Alan's, who would be more than happy to engage in social justice. We just have to be able to be ready when the call is made. I don't have 20 associates or 5 paralegals or a manager who can give me a budget to do discovery. But I do have some people who are committed. And for those of you who have that type of resource, utilize it. The one thing I can say about this guy is he's always been smart. And so if you are a hardworking, smart lawyer whether it's on the civil side or the criminal side, you're still a good lawyer. The difference is you may have a kid who has been wrongfully convicted. They had a lawyer who may have been a public defender who was overwhelmed. I see these young lawyers every day, and I'm so proud when I see the students, whether they're from Tulane, but primarily from Tulane or Loyola, and they're practicing either in domestic court with a domestic violence issue or criminal district court. And the fire that I see in their eyes, the desire that they bring to court, it's exciting. But there's so many of us who have had the benefit of an education at this great institution that we've just taken it for granted. I try very hard to avoid the media these days and giving comments when I don't have to on behalf of a client. But there's so much work to be done in the area of social justice, whether you help a family who lives in Cancer Alley, or you help save someone who's been a victim of domestic violence. You have a kid who's in a juvenile program who may have had a mental crisis and engaged in conduct that has resulted in that child being charged, in the potential of the child ultimately being prosecuted as an adult. There's something that we all can do rather than having the intellectual discussion about how sad it is, how unfortunate it is. Gee, I wish I could do something. Well, there's always something. It's something that we all can do. It just takes some effort. It takes a commitment, and it takes some time, or it will take your money, or a combination of both. So there's something that we all can do short of sitting around complaining, bemoaning, or just simply sticking our head in the sand. Because eventually, whatever problem you're trying to avoid will come to your doorstep. No matter where you are, where you live, or what you try to do, you will be affected by the social ills that you either choose to engage in, to address, or run from.
Well, I promised our development staff that I'd give them a moment at least to talk about how we can support the clinics financially. All right. And then we'll take questions if anyone has them.
Thank you guys for joining us. When we were putting together this session, I mentioned that I would be remiss by giving you guys the option to support our clinics. Are so many wonderful clinics and the wonderful work that our students are doing in this space. So if you are interested in supporting the clinic, me and Angelina and Trev or Jonathan, we're all in the front. You are interested in all or of how you can help, if it's time that you want to give, or if it's money that you want to give, or if you want to give both, go ahead. Give it a shot. And I'll let it go to Alan for
All right. Thanks, Sasha. Anybody, questions, comments? Go ahead, Trev.
I wondered if Katherine could talk just a little bit about the interest of our students right now in clinics.
Yeah, it's been soaring. I mean, I will tell you, I think I don't have the numbers at my fingertips, although I shared them, I think last year, that we just had an astronomical number of students wanting to be in clinical programs. I think that there's just been this real stir, since everything was locked down, and we've heard about all the social justice issues that are going up and that have been in the forefront of our lives and in the news for the last few years. It's just really stirred with our students a real passion for getting out and having that hands-on work. And I have to say, I'm very proud that, I hear it time and time again, and I've heard it since the beginning of my doing this work from students who talk about their clinic experience as one of the most moving, informative parts of their law school education. Not that the rest of law school isn't wonderful, but that clinics really are that sort of special experience. And, you know, they get to connect with a client and they get to see the difference that their regular education, you know, the first 2 years of studying appellate cases, learning how to think like a lawyer can be really abstract. But when you come in the clinic and you finally get to sit with a client and you get to, you know, hand them the check, or you get to say that, you know, yes, an injustice was done to you. Those moments are truly the moving moments that capture people's hearts and make them know and understand why they practice law and why practicing law is a really valuable and important part of making our communities and, you know, run.
Yeah, I will say at the law firm, big law firm level, the enthusiasm of my associates for this kind of work is tremendous. I have to turn lots of them away. You know, I can't have an unmanageable team, but it's they really are beating my door down to work with me on these cases. So, and it's really important, I think, because if you instill in them a sense of responsibility for social justice early on in their career, it's something that will stick with them for their entire career.
I hope if I can take 1 second and share a really quick story, and Clarence has heard me tell this story before, but you're gonna have to hear it again, and I will abbreviate this story. But I became very close friends with a man who was inmate counsel sub. He was incarcerated, serving a life without parole sentence, and he served 28.5 years. And every year I'd bring my students up to go meet with him and to Angola, and he'd explain how counsel subs work and how the law library works. And he'd written many, many briefs and gotten many people out of jail himself, even though he was incarcerated. And he was represented by the Innocence Project, and finally was released after 28.5 years of a wrongful conviction. He was released. And the day he was getting released from prison, he calls me on the phone. He wouldn't hold it. His lawyer had to hold it by his ear because he was afraid of the phone. But he called me and said, I want to come to the law school. And 4 days after being released from prison, he came to the clinic with students that he had just met previously at the law library. He came to the clinic and he was so excited, and the students were so excited. And he just like, I always wanted to see the law school. I've always wanted to come and find out where it happens, where all where you all study. And the students were so excited. And he said to them, what I really want to see is the law library. Can you take me to the law library? So, and these are all my third year law students, right? They're a little tired of the law library, but sure, okay. We're going up to the law library. And we go up to the law library and there's stacks of books, and he starts walking up and down the stacks, looking at all the books, and the students are like so excited. Oh yeah, look, that's there and that's there. And they're showing him everything and he's all giddy. And then all of a sudden he stops and he turns to the students and gets very serious. And he says, look at what you have here. What this is power. Use it wisely. And I always have to return to that, because what we have as lawyers is power. And we have an obligation to use it wisely. And I think that's what Clarence and Alan have been talking about, is we can share in that power.
Thanks everyone for your attendance and attentiveness.
Thank you.